Hello, I'm Janet, the Executive Director of Priest Life. Welcome to Just Yes Canada. Still getting my program in Father Frank's slot in the evening. Normally I'm tuning in to me a little bit earlier, but I'm being the placeholder, so to speak, while he is recuperating from his open heart surgery. And again, he wants to thank you guys for all the prayers and well wishes. I mean, he just went to the surgeon yesterday. And the surgeon said, you are doing amazing in your recovery. You still have a few more weeks to go. But he said, you are doing fantastic. So he got a big thumbs up from the surgeon. So again, thanks for all those prayers. Well, joining me today is a great pro-life warrior, a great pro-life hero, someone who fights for us pro-lifers all the time in the courts of law. And in fact, he fought for Priests for Life when we had to fight the HHS mandate under Obama. We went all the way to the Supreme Court. See, it wasn't just the Little Sisters. We were there too. So I'm going to introduce to you now my dear, dear friend, Robert Muse, Esquire, and he is the president and founder of the American Freedom Law Center. Robert, welcome to the program.
Thank you, Janet. Great to be with you. And, while Father Pavone is certainly irreplaceable, so are you. So I don't consider you just a placeholder. This is just, more, great substance. You're just filling in for him right now, but both of you are irreplaceable life warriors. So thanks for having me. I appreciate it.
Well, and, I just want to remind everyone that, you with a law firm that took our Priest for Life case, I remember being in court with you with the district court in D.C. And then, of course, as you know, it was us plus, everyone focused in on the Little Sisters, I guess, because making Little Sisters go to jail sounds crazy. But it was really, there were 7 or 8 groups, weren't it, that were in that initial suit before the Supreme Court, right?
It was. And our case was consolidated with the Archdiocese of Washington. And so we worked very closely with Jones Day and their lead attorney, who was Noel Francisco, who actually was President Trump's Solicitor General. Great lawyers. But our petition actually to the U.S. Supreme Court, because the case before the Supreme Court was titled Zubik, was the lead plaintiff, Bishop Zubik. And we actually had the second petition that was granted. So it was only within a matter of probably days or weeks, the case would have been Priest for Life versus. But we were one of 7 that the Supreme Court granted review, consolidated the cases. Little Sisters of the Poor was obviously one of them as well. And so all those cases went up as one before the U.S. Supreme Court.
Okay, and I just want to remind, before we get into the Mississippi case, I just want to remind everybody now, we know President Trump took all that away and we were great and fine. But then the Little Sisters ended up back in the Supreme Court, because of why? Something happened again, right?
Yeah, there's issues, and they're still working their way out with some of the changes that were made by President Trump, and the question of whether they, meant the Administrative Procedures Act, and it kind of gets into into so many weeds as to how this is unfolding. We have a consent judgment that was entered into by the government, signed off by the judge, protecting Priests for Life. So we're kind of keeping an eye on seeing where this is going to be heading. And I believe Little Sisters of the Poor actually intervened in the case to make their arguments on their behalf about these regulations that the Trump administration put in place to protect religious liberty. But this is going to always be a battle. There's no doubt about it. Elections have consequences. Some administrations are pro-life, and some certainly are not. And it's very interesting because, and as you may recall, when the Zubik case got returned back down, and basically the justices said, "Hey, parties, work this out between you so you can protect religious liberty and get this resolved." And originally, our negotiations were with the Obama administrative officials, and it was like talking to a brick wall. They could have cared less about religious liberty. That they could have cared less whether you had any interest whatsoever in challenging this mandate. Well, then the election happened, and then shortly after that, we started negotiating with Trump appointed officials in the Department of Justice, and it was night and day. The Trump administration seriously cared about religious liberty and was seriously pro-life. Quite frankly, in the most pro-life administration in my lifetime was the Trump administration.
Yeah.
Now we have the Biden/Harris administration, which is hardcore pro-abortion, anti-religious liberty, and we're seeing it play itself out.
Yeah, it's terrible. And so now, the Supreme Court's a little bit different. Thanks to President Trump, we have 3 brand new conservative justices, right? Pretty exciting, I think. I mean, who would have thought, right, Rob, that we got Gorsuch, Kavanaugh, and then Amy Coney Barrett? I mean, that was like triple play, grand slam. I can't believe it. But so now this case, so that everyone understands, tell us this Mississippi case, what happened in Mississippi that it's now, of course, the pro aborts are challenging their law, but how did it get up to the Supreme Court?
Well, Mississippi passed a law called the Mississippi Gestational Age Act, and it prohibits abortions with very limited exceptions, not some of these, very broad exceptions, which tend to swallow the rule. That after 15 weeks gestational age, abortions are prohibited. And the district court enjoined the law. It went up to the U.S. Court of Appeals for the Fifth Circuit, and they held that law was invalid because it was essentially a ban on pre-viability abortions. So it was any abortion from 15 weeks, onward was going to be prohibited. Now, under the case, and try to explain this without getting too much in the weeds of the legalese, under the government can regulate abortion pre-viability, but they can't ban abortion under the Casey framework. Right? They can regulate regulate abortion. For example, hospital admitting privileges or informed consent laws and things that don't go right to banning the abortion itself. The standard they typically would apply after Casey was this undue burden test. And the undue burden test is essentially, does this regulation place a substantial obstacle? That's the language from the cases, and obviously what does a substantial obstacle mean? And that's, for the justices to argue out, and it usually falls in, along the lines of what your, political affiliation is at the Supreme Court. So if you place a substantial obstacle in the way of a woman getting an abortion, if this regulation of abortion, then it's struck down. But they've held that, the government's interests come into play once viability, is an issue. So here, where there's a total ban on abortions at, beginning from 15 weeks, which they found is not, the time of viability, that they don't even get to the undue burden test. It's a ban on a pre-viability abortion. And so based on the, what they described as the unbroken line of cases since Roe versus Wade, those types of bans are automatically unconstitutional. And so they enjoined, meaning they issued an order halting this law as being unlawful, as a ban on pre-viability abortions. So it went up to the Mississippi filed a petition for a writ of certiorari, that's what it's called, to the Supreme Court. And I'm sure your listeners and viewers are been following you long enough to know that the Supreme Court review by the Supreme Court is not automatic. It's discretionary for the vast majority of cases. And so you file a petition for a writ of certiorari, meaning you're asking the court to review this case, and it has to have a substantial question for the court to take up, right? They don't just it's not just another appellate court. You've had your chance for your appeal as of right to the appellate court, in this case, a 3-judge panel of the U.S. Court of Appeals for the Fifth Circuit, and they upheld the ban on the law. And so Mississippi filed their petition for writ of certiorari, and they presented 3 different questions to the court for the court to grant review. And the way it typically works in the court is they call it the rule of 4. There has to be at least 4 justices who agree that this case is the issue presented is a good issue for the court to take up, and that this case is also a good vehicle for doing so, meaning procedurally and evidentiary wise and all the other things that take place down in the district court with the evidence and the arguments and so forth, that this case is a proper case to take up to address whatever one of the questions, if not all of them. They can grant review on one of them or on 3 of them, as the case was presented, the petition, and they granted review on 1 question. And this is the part that gets quite interesting, because they granted review on this question. So at least 4 justices had to agree that this was a worthy question to be brought up, and that this was, again, a good vehicle for doing it. And the question is whether all pre-viability prohibitions on elective abortions are unconstitutional. Very interesting, because if you had to have 4 justices take this up, and it's not, to just have a simple answer whether all pre-viability prohibitions on abortion are unconstitutional. If it's just a simple yes, right, that's not that doesn't seem like a case that the Supreme Court would take up. And even with 4 of them, they must have a sense that there's likely a 5th out there that possibly could say, you know what, there's something more here to this. And how do you get to, and this is the part that's very intriguing, because I've been thinking about this quite a bit. Why would they take this question up? Right? So if all pre-viability abortions are not, as a matter of course, unconstitutional, then that's going to cut back on Roe. It has to. I don't see how it doesn't, because we already have the Casey framework, where if you have a regulation on a pre-viability abortion, it's the substantial obstacle test, but the state interests don't really start coming into play until viability. Well, there must then be some state interest that they recognize pre-viability, or else there's really no reason to take this case up. So it does present a very interesting question that the Supreme Court decided was going to be important enough for them to take up. And I don't know, I've been thinking about how do you get around this unless they say, well, we're going to back up the substantial burden test and apply it to pre-viability abortions. Well, then you got to bring the state interest into it. I'm very intrigued by the fact that they took this question up, and for it just to be a simple, yes, all and that's basically what the Fifth Circuit held based on prior case law. It's like, look, this is a restriction on pre-viability abortions. It restricts abortions at 15 weeks. That's pre-viability. So under prior precedent, it can't stand. So they're going to take this up and answer that question. And I don't see how they can answer that necessarily without cutting back in perhaps in strong ways against Roe versus Wade. So it's I find it a very intriguing situation that we're being presented, and hopefully, that it doesn't end up being just a simple, Roberts goes with the pro aborts and someone else, and then you're back at, just a simple answer like we just reaffirm, what Casey said. So I'm hoping we get something. There's going to be something a lot more there, and my sense is there is going to be. And so this is going to be very interesting to see how this works itself out.
Well, Rob, I always find that this whole viability thing is it's like a moving target anyway. As you know, there's always this disagreement right now in the medical community where we've had babies survive at 21 weeks, but yet some doctors said viability more at 24 weeks. Well, by the time they get to 24 weeks, the baby can survive. And in fact, there's a great pro-life couple. They're active in several organizations. They had a baby 4 months ago, born at 24 weeks. And what happened was she got admitted to the hospital though at 21 weeks. And the doctor said, well, if we can't, stop down the process here and get you to hold that baby for another week, 2 weeks, then there's really nothing we're going to do. They basically were telling them if this baby's born at 20 or 20, they would just, it's kind of like let the baby just linger there, or whatever. The baby, thank God, everyone was storming heaven. And, she got to 24 weeks. She's still in the NICU. It's, she's 4 months. She's still struggling, but she's a fighter. She's up to, I think, 5.5 pounds now. It's, she's coming along. But what interests me is this whole viability, because if they rule now about viability and it's at, they say 24 weeks, but what if we get down to 20? And then, it's like, to me, it's a moving target, the whole viability thing, right?
It totally is. Because that's always a great question, Jenna, because it's when you look at, when Roe v. Wade was decided, they're doing this trimester framework, but the viability issue, as medical science continues to improve and our ability to care for these babies in the NICUs and so forth. That's the viability, and that's why it's kind of interesting, because they might just get rid of the viability framework because it is a moving target constantly with science, and they might and that's why it's very interesting, because again, the question is whether all pre-viability prohibitions on elective abortions are unconstitutional, right? So a component of that might be, yeah, the whole viability framework is just not even workable, because that's going to constantly be changing as medical science changes, as new innovations develop. My two of my granddaughters, twins, they were born, in, I forget exactly which gestational week, but one was 1 pound 16 ounces and the other was 2 pounds 11 ounces. In the NICU, you see these tiny little babies you can hold in your hand. My son-in-law has a picture of his wedding band on all the way up to the shoulder of one of the little girls. They're 4 years old now, and they're the most precious little girls. But when you saw them in that NICU at 1 pound 16 ounces and in 2 pounds, plus, it's incredible what they can do today that they couldn't do certainly back in the 70s with Roe versus Wade. And who knows what developments in medical science will occur 5-10 years from now. So that's part of it, kind of almost built into this question is the point that you're making. How can viability really be a logical measure? And then, oh, by the way, why doesn't a state have an interest in this human being, right? Because it is a human person. We know, two humans aren't capable of producing other than a human, right? And we know that there's a life in there. We can hear the heartbeat. We know that this child is developing and will develop into a human person, right? Why doesn't a state not have an interest even at that pre-viability time? So that's why this taking this question up, I find to be very, very interesting, and I can't wait to see how this comes out and how it unfolds. Because, and again, your question was again a very, very good one. And I think it's built into the nature of this question. Viability is not really a good measure, right? Because it's human life, right? That's what we're talking about here. And why isn't there an interest prior, and why won't medical science, take that on earlier? So it'll be very interesting too if there's enough justices that have the guts to go back to the Roe, just the overall underpinnings of Roe versus Wade, and address this question from a state's interest question, right? Even go back to that very fundamental question. I don't think this court would say that the unborn child is a person under the 14th Amendment and therefore, all abortions are unlawful. But is it beyond the pale to say, well, you know what, we've looked at Roe versus Wade, and this is really a state's issue, right? This has been too divisive in this country, and states should be able to weigh in and say what their interests are, right? And so you're going to have your New Yorks and Californias who are going to be, these pro-abortion bastions, and they've made sure to, enshrine it in their own state constitutions, anticipating perhaps someday that, Roe may fall. And then you have places like Mississippi, which will be pro-life states, and others. And so who knows? I mean, it's, we can pray for a miracle in the Supreme Court. With God, all things are possible. And this, we'll see. We'll see what direction they go in this.
Yeah, and what, Rob, is very interesting that people don't realize is the viability argument was not part of any of the arguments. Roe was argued actually twice before the Supreme Court, as we know, but in none of those oral arguments was viability there. From what I understand in reading things, viability was kind of like thrown in by the justices at the last minute. And also, too, people have to realize that back then, there was no such thing as ultrasound. We didn't have the technology back then we have now to really look at the unborn child. So I remember one part says, well, you kind of really don't know exactly when life begins. And so therefore, but viability wasn't even a concern. So maybe I think we're getting at here is just maybe they're going to throw out viability altogether and allow states themselves to regulate abortion, which is kind of the way it was before Roe. There were 5 states that had legalized abortion before Roe v. Wade. And ironically, Rob, where Father Pavone and I are from, New York, all these decades, abortion was only legal in New York State till 24 weeks, because that's what it was before Roe, right? So 24-week stayed in New York State all these decades until just a couple years ago, they made it now till birth, right? Yeah. So, I think what you just said, like about California, New York, California, Vermont, we know the states that will enshrine, and that's what they're trying to do now, Roe. But then there's so many pro-life states that have already passed some good pro-life laws. Look at the states, how many states have done heartbeat bills, right? Mm-hmm. And of course, those are being fought in the courts right now or being held up. But you see, I think the sentiment in our country is a much more pro-life sentiment just by what the rights of the people in the states are. And to me, this is going back, and it kind of pins back to what you're about, the American Freedom Law Center, of the intention of our founding fathers and our Constitution was of the people, by the people, for the people in that area, and not have the big arching federal government dictating. That's what we had in England, taxation without representation is tyranny, right? So don't you think that this is the way we're going to go?
Yeah, I couldn't agree more. One of the things that our founding fathers intended was for there not to be, a national voice on things, because what's right for Nebraska is not the same thing that's what's right for New York, right? We had this concept of federalism. And our federal government was supposed to be the government of limited and enumerated powers, and the states were supposed to have far more broader powers, police powers, which they didn't grant to the federal government. For Congress to pass a law, they have to find authority for it in the Constitution. They don't have general police powers. But of course, we know from the Commerce Clause and the way the courts have read it over the years, it's made it very broad. And so the federal government is there all the time. And the other thing that's interesting when you think about the courts were going to be the weakest branch of the three, right? They didn't give our founding fathers didn't give them the power of the sword. They didn't give them the power of the purse. But yet the courts have become now these super legislatures. And Roe v. Wade is the quintessential example of the problem when the Supreme Court wants to decide something, for all the people of the United States in a way that our founding fathers could have never have imagined. Right. And so there's been, most people probably thought, after Roe versus Wade, here we are in the 70s, that question's decided, the issue's over. No, it's still the most divisive issue in our country, in my view. And quite frankly, as I've said before, it's become the litmus test as to, Supreme Court, who's going to be in the courts, not just at the Supreme Court level, but at the appellate court level and the district court level. It's worked its way all the way through. So it has corrupted our entire judiciary. And if anything, it's time to say, look, we're not going to be in the business of doing this. This is for the states, for the people, for the democratic process to work itself out. You want to be in a pro-abortion state, you go live in California, you go live in New York. You want to be in a pro-life state, you go to these other places. And then we fight these battles at the grassroots and at where state constitutions, many of them can be changed a lot more, easily through ballot initiatives and so forth. But let the process make its way through. And who knows, maybe this court might have the guts to do that and to issue a decision where they can explain to the American people very well that, look, this has never been an issue that should have been decided just by 9, not even 9, a majority of 9 unelected, really political appointees sitting on the bench. So this could be very interesting. I'm really anxious to see how this will work out, and we won't have a decision likely until next June. And given the nature of this, it'll probably be one of the last decisions that they release before they go into their summer recess next year. But there's going to be some fireworks.
Yeah, and I'm going to enjoy the fireworks too, because, Rob, I think this, for me, and I talked to Father Pavone about this, it's a great opportunity for education for us. Just like I remember with the partial birth abortion ban and that whole fight, people woke up and said, what? They're doing that? That's inhuman. That's bizarre. That's terrible. And so people rose up and said, no, that's going too far. And I think this too is going to wake people up to even hear these terms about viability and think that, oh, the babies, they're being aborted when they could be saved and they could live. And, so I think it's going to create a great time for us in the pro-life movement to come on, get excited. Education is going to happen. And my prayer is that they kick out the viability and kick it back to the states. And that basically is going to undo Roe in a different way than just trying to overturn it. Right. It won't be like totally overturning it, but it'll be pushing it back to the states and saying take out the undue burden nonsense and get rid of viability. Right. Yes.
And your point about education is an absolutely great point, because as I tell people all the time, look, if you can convince people, of the violence of abortion, not only to the unborn, but to the woman, and so that nobody wants to have an abortion, it goes away. Right. Who cares what the Supreme Court says? Right. And so that is always such a crucial, critical component of all this. And I totally agree. This case gives an opportunity where this issue will be front and center, and groups like Priests for Life to be out there and to educate people about the violence of abortion. So this is a win-win in so many ways. but it's
Yeah.
at bottom, it's the best opportunity to educate, evangelize people. So I said, we win over their hearts and their minds. Who cares what the courts are doing? And that's more crucial than anything that can happen in the courtroom, is our ability to reach people, which is precisely what you do and Father Pavone and Priest for Life, better than anybody I've seen in my decades of doing pro-life work. So that is a crucial aspect of this that people can never forget. Don't just rely on the courts to decide these issues, because most of the time the courts will disappoint. Reach out to the people, evangelize them, and teach them the truth. And that's how we will ultimately prevail.
So in our closing, I'm going to ask about my tea leaves here. And here's my prediction, Rob. We'll see if it comes true. I think if we win this decision, that they're going to let Amy Coney Barrett write the decision. Okay, that's my guess. If not her, my second pick is Justice Thomas. I think those are the lead two that I would pick to write this decision. I think we can guarantee on the vote affirmative for Alito. And I would even go so far as for Gorsuch and Kavanaugh. Kennedy, of course, but we don't need him anymore.
Yeah, well, Roberts.
We don't need him.
Roberts is Kennedy. Yeah, Roberts. Right. Yeah, he's on the other side. But
I didn't mean Kennedy. I meant Roberts. Yeah, I meant Roberts. Gotcha. We could never predict, but we still have enough. But I think this is a great time to shine a light on your former colleague there in law school there, Amy Coney Barrett. That I think let's watch her. I'd be very interested to see. Right.
It's my classmate, and she's tremendous. She's wonderful. And, who knows? This is, God put her at this time, at this place, and how her confirmation went through was a minor miracle, but she was the perfect person at that time to get through, because she was Teflon coated, and she would be the ideal person, her or Thomas. But I think having a woman write it might outweigh everything else. So I agree. I like your prediction.
Great. Well, just tell everyone quickly where to locate your organization, because pro-lifers, if you have a problem, Rob's your man.
Thank you, Janet. Yep. AmericanFreedomLawCenter.org.
That's great. Like I said, they defended Priest for Life, did an awesome job. And I know they help a lot of other pro-lifers all over the country, that when the pro-aborts are after them, you guys are sticking up for us. So thank you for all you do, and give our best also to your colleague, David Urashami. So say hi to him too. All right.
Will do.
Okay. God bless you. Thank you. Well, brothers and sisters, I hope you enjoyed that discussion, because, we've got to stay tuned to our Priest for Life website, priestforlife.org, our action alerts. As things progress, we'll be telling you what you can do, how you can educate others. Because believe it or not, those people in the justice on the Supreme Court, they're human beings. They do read the newspaper. They do hear what's going on. So public opinion is very important, and we're going to be out there fighting. And remember, brothers and sisters, there are some abortions only you can stop, and some lives only you can save. Tune again next time for Just Ask Janet. Thank you.